Hello, and welcome to our Practising in the Youth Court webinar. My name is Richard Williams. I'm a policy manager at the SRA, and I have responsibility for making sure that solicitors practising criminal advocacy meet the standards we and the public expect. So what we're going to talk today is about the youth court in particular, why practising in the youth court is different, some of the challenges that solicitors face when practising, and importantly, practical tips for solicitors to make sure that they can provide good advocacy in the youth court. The webinar is very, very timely, as we've recently published a good practice guide for solicitors practising in the youth court. It sets out our expectations of solicitors practising in this area, and you'll hear a lot more about that later. So today is May the 4th, and that's Star Wars Day. So I'm really pleased that we have a stellar set of panelists who are Jedi Masters in the field of youth court practice and who have been instrumental in helping us develop our good practice guide. So I'll start with some introduction. So I'm really glad that Kate Aubrey-Johnson is joining us today. She is a barrister and youth justice expert at the Garden Court Chambers. We're also joined by Katia Moran, who is a solicitor and co-head of the Youth Justice Legal Centre. Helen, whose name doesn't begin with the letter K, Helen Richardson is a policy research officer at the Magistrates Association. And we're also joined by Ben Burns from the SRA, who played an instrumental role in developing the Good Practice Guide. Just before we start, a quick reminder about how our webinars work. We want this session to be as interactive as possible. We have already had a good number of questions sent in advance, and we'll be picking these up as we go through the session. But you can also submit your questions live by clicking on the link below the video. You can include your name with your questions, or you can have the option to provide a question anonymously. We will try and answer all of your questions as we go through the webinar. So the final point on kind of practicalities is really that the stream will be available on catch up. So will the slides, and any links to relevant web pages will be available on the resources pages on our website. So feel free to share with colleagues. So that's all the introductions I'm done. Let's kick off. So Kate, perhaps I can start with you really. Can you set the scene a little and describe why practising in the youth court is different and why good advocacy is so important in the youth court?
Thank you, Richard, and thank you for having me today. I think the first thing is just to talk about the youth court, what the youth court looks and feels like. It's been designed to be a specialist court for children. So it should be more informal in layout and in terms of where everybody's seated. Everybody should be seated on one level. And in terms of the way people communicate, lawyers and judges and parties to the hearing should all be communicating at a level that children can understand. And it's a closed court, which means that the public can't enter, which is a challenge for solicitors because it means that they can't just sit and observe more experienced practitioners. And the other thing is that the Youth Justice Service, formerly known as the Youth Offending Team, play an instrumental role in the youth court. The thing about the youth court that is also really important to remember is that it hears cases that are much more serious than the adult magistrates court. So the powers of sentencing in the youth court are up to 2 years, which means that the type and gravity of case are much more serious in the youth court than they are in the adult magistrates court. And of course, there are distinct legal procedures and also protections for children, which make the law far more complex. But why good advocacy is important, and that's what you asked me, is because of the cohort of children who come to the youth court. It's really important they're able to understand and follow proceedings. But what we know about the children who come into contact with the justice system is the vast majority, at least 70%, and as many as 90%, will have speech, language and communication needs. There's also a much higher level of neurodiversity, of ADHD and autism spectrum disorder and other neurodevelopmental conditions and mental health needs. But what's also important for solicitors to remember is that research suggests that as many as 92% of these children are undiagnosed when they come into contact with the justice system. So lawyers have to be really aware of the communication challenges of the children that they are representing. And what's really important is children understand the process they're going through and that they feel listened to, because procedural fairness is really important to children. They need to feel that they've been through a fair process in order for them to follow and be successful in any sentence or any consequence that comes out of the criminal process, and for them to feel that the law is fair so that they obey the law in the future.
Thanks very much for Kate. Some really gnarly issues there. And I just wondered, from a practitioner's perspective, Katia, what do you see the challenges that solicitors face in providing good advocacy in the youth court?
Well, Richard, I think that probably anyone watching who has practiced criminal work in the legal aid sector will be very aware that it is challenging on many levels. It's poorly remunerated, it's low status work, and the work itself is really challenging. Kate mentioned the really serious nature of lots of the cases that come through the youth court, and the fact that you're dealing with a child only compounds that. But as well as the kind of working environment, I think a really big challenge is that historically there hasn't been a requirement for lawyers representing children to be specialist in terms of being child law specialists, and that's led to culturally a kind of misunderstanding or a lack of understanding about what it really means to be good at representing children. So the knowledge and skills that lawyers need to represent children well aren't typically legal or lawyer skills. They need those as well, but there are additional skills that they need. And so the challenge is for those solicitors to find out what knowledge and skills they need in order to be able to represent children well. And then once they know that, to actually go about upskilling themselves in order to be able to do that.
Thanks, Katia. And I think that touches on the good practice guide that we've published a little bit earlier, which will come on later in the webinar. Helen, I just wondered if I could come to you now and get a perspective from the magistrates and the Magistrates Association. And what do you see as the key challenges that solicitors face when practicing in the youth court?
Hi, Richard. Yeah, lots of the things are reflective of what Katia and Kate have already said, but I think from magistrates' perspective, they understand that solicitors are incredibly busy with high caseloads, and that, as Katia said, it's relatively low status work, or it has been in the past, youth court work. And that's kind of a flip for how it's treated by the magistracy, in that magistrates have to undergo specialised training in order to sit in youth courts. They have to go through a whole additional process of training, appraisals, and ticketing in order to be able to sit in the youth court. And therefore there's a disconnect between what youth court magistrates expect to see in youth court versus the lack of expectations there's traditionally been for professionals appearing in the youth courts. And so that disconnect leads to quite a lot of confusion for magistrates, who expect to see quite a high level of engagement with the child, and then can lead to friction in the court if that isn't reflected by the way that advocates approach things. And I think one of the key areas where that comes into play is that there's lots of moving parts within the justice system, particularly in the youth justice system, and magistrates expect practitioners to be aware of all of the moving parts, to be aware of local practice, of what the youth justice services are offering, and that collaboration across the prosecution, defence, youth justice service, and then with the bench is something that is really key, but is not necessarily a standard expectation currently.
Yep, I think
Sorry,
I managed to lip read you there, Richard. Yeah, I mean, I think I'd really just want to echo what some of the other speakers have said about the importance of having up-to-date knowledge and skills for engaging effectively with vulnerable children in the youth courts. And I think Kate's point that 70 to 90% of children in the youth justice system have speech, language, and communication needs really highlights the importance of doing that effectively and the challenges it can present for solicitors. And just to add, right at the end of 2021, we published the findings of our review of the training records of about 360 solicitors from about 120 firms. And although we found that most solicitors were taking steps to keep their knowledge and skills up to date so they remain competent to practice, we also found that only 4% of youth court solicitors were undertaking learning and development to engage effectively with vulnerable children. And given, as the other speakers have said, that's a fundamental part of effective youth court practice, and it's a specialist and challenging skill, that finding was a really key driver of our decision to publish the Good Practice Guide for Youth Court Solicitors, which I know we're going to talk about in a bit more detail later on.
Thanks, Ben. And I seem to have mysteriously got my voice back now, so apologies for that. Helen, just to kind of round up this section on, I suppose, the challenges of practicing in the youth court. What do you think kind of are the themes of poor practice that magistrates see in the youth court?
So, with the greatest of respect to the fact that this hasn't been a prioritised area, you don't have to be specially ticketed to sit in the youth court. There are a few themes that we pick up from our magistrate members about particular issues that they see that aren't aligned with how magistrates are approaching the youth court process. And so I think one sort of very much touches on what Kate was saying before about a lack of familiarity with different procedures. And so addressing the young person directly is something that magistrates expect to be able to do. But we've heard from members that they've been sort of precluded from doing so or cut short from doing so by a legal advocate who is wanting to talk on behalf of their client, which of course is a normal legal skill that you'd employ in the adult courts. But in the context of the youth court, it's so important that the judges or magistrates are able to directly talk to the child in a very open conversation, not just one-word answers and things like that. Having a discussion with the child, research has shown, allows the child to feel much more engaged in the process and therefore trust the process and trust the outcome. And it makes a massive difference from the way that magistrates are perceived by the children in the youth court. And I think, again, with that sort of slightly different additional skill, as Katia was saying, having a much more collaborative approach and style rather than adversarial style is something that is very important in the youth court, but magistrates often see it become a much more of a battleground, and they want to be seeing this collaborative kind of style. And then there are other things that potentially are out with the power of a solicitor to change, but things like not having courtrooms adapted, as Kate was saying, making sure everybody's on the same level, avoiding the use wherever possible of secure docs. And I think that from solicitor's point of view, if you know that those things should be in place, if there's any opportunity for you to see that your client's going to be appearing from the cells, making sure that they're not brought into the secure doc, making sure that you're in a courtroom that doesn't have magistrates raised up and things like that. If you have the time to be able to employ that kind of thing and you're aware that that shouldn't be happening in youth court, it'll make such a difference to the experience that child has of the youth justice system.
Okay, thanks very much for that, Helen. Let's move on now to talk about what good practice looks like in the youth court. And Katia, perhaps I can come to you. What would you describe as the key components of good practice in the youth courts?
Well, I think, lots of solicitors aren't going to be representing children day in, day out. They're not going to have huge caseloads. But when a case does come up when they're representing a child or dealing with a child, then they really need to recognise that the law, the process, the system is very different to the adult court, and they need to understand how it differs. So they need to really do their research in advance. An example would be if you had, something very sort of run-of-the-mill, like a bail application, it's too late on the morning of the hearing to start trying to understand all of the differences. You need to do some research in advance to familiarise yourself with how the law is different, what the rules are, how practice is different, who are the other people you need to be speaking to in the court building, child's family, etc. And bail is just one small example of numerous things like that could come up. So I think that's the absolute minimum of good practice. And then there are some other issues, like the fact that care experienced children and black, brown and racialized groups of children are overrepresented throughout the youth justice system. Is having an understanding of that and why that is absolutely fundamental to practicing as a competent youth justice lawyer, in my view.
Thanks for that. And you've touched on there, obviously, kind of skills, knowledge around the youth court. Hey, perhaps I can come to you. And is there anything you wanted to add to what Katia has said in terms of what good practice looks like in the youth court?
Well, I think Katia has captured it really well. I think it's really important that you acknowledge that going to the youth court, there's going to be a completely different set of legal principles that are governing the decisions being made there. And Katia touched on bail and remand. That's a really good example where the legal framework when dealing with children and bail and remand is completely different from adults. And solicitors need to really familiarise themselves with that. And we're aware that there is a shrinking number of children coming into contact with the justice system, and a shrinking number of children going through the courts. There are less youth courts sitting, and so it is a challenge to keep that expertise and knowledge up to date, and be aware of all the changes. But alongside that, I think it's always having at the forefront I think I cut out there. I think it's always having at the forefront of your mind the underpinning principles that underpin all cases in the youth court. The court has to have regard to the child's welfare, and that the purpose of the youth justice system is to prevent offending, and that they should be governing everything that you're doing, the information you're gathering, and the information that you're presenting to the court. And the wider contextual knowledge that the criminal justice system is in fact criminogenic. And what I mean by that is that research shows that coming into contact with the formal criminal justice system actually increases the likelihood that children will go on to reoffend. So there is a presumption in all cases that children should be diverted away from the formal criminal justice system. The youth court has sometimes been described as a guilty plea factory, because children who plead guilty for the first time should receive a mandatory referral order unless the case is very serious or very or a case where maybe a conditional discharge is suitable. And so actually, if you've got a child indicating guilty plea, you should be thinking about diversion. Have all considerations for diversion been considered? And view the case through a child's lens. It's very easy for children to be escalated through the criminal justice system, when in fact, when you understand their lack of maturity, the influence of peers, if you look at the offending, it might be very childlike. Examples of children who end up with criminal convictions are children who've thrown a cake on a bus, children who've done very childlike things that has caused them to formally break the law, but actually is a criminal record. The right approach, is it in the public interest to saddle that child with a criminal record for the rest of their lives? So those are sort of aspects that I think are really important that practitioners going to the youth court have at the forefront of their minds.
Thanks, Kate. And I think what's coming out very strongly is through the discussion so far is obviously that the youth court is a particularly challenging and complex arena, and it is really important that solicitors we regulate kind of have the right skills and knowledge and behaviours to meet some of those challenges, so that the best outcome for children are achieved. Ben, with that in mind, can you just tell us a little bit more about the SRA's Good Practice Guide for Youth Court Solicitors?
Yeah, thanks, Richard. Yeah, I mean, the Good Practice Guide in many ways does what it says on the tin. It sets out what good practice in the youth courts looks like and reflects the key challenges of practicing in the youth courts, which Kate, Katya and Helen have touched on. We worked with a range of experts, in addition to Kate, Katya and Helen, people like the CPS and youth justice team, to identify what the key challenges are and what the key components of good practice are. In terms of the guide specifically, it's split up into 4 sections. So the first section is up-to-date knowledge and skills, and that kind of reflects some of the things Katya was saying about making sure you're familiar and that you do research about how law practice and procedure in the youth courts is different. For example, in relation to bail and remand, and also links to Kate's point about making sure you understand the underpinning principles of the youth justice system and the youth courts, and that you kind of carry those principles through and reflect it in your work. It's also having wider knowledge of things like childhood development and childhood offending, and I know Kate and Katya touched on that as well. And then the second section of the guide is awareness of the background and needs of the children you're dealing with, whether you're representing them or prosecuting them. And this section really highlights the need to be proactive, whether that's proactively identifying any specific needs that a child in the youth court may have, when diversion from the criminal justice system can be promoted, and I think that was a really important point that Kate touched on, that principle of diversion, and when wider support, whether it's from intermediaries or other organisations, would benefit the child in the proceedings. The third section of the guide kind of sets out some of the specific skills of effective communication and engagement in the youth courts. And some of them might read a bit obvious, but I think in practice can actually trip a lot of people up regardless of their level of experience. For example, just making sure that on an ongoing basis, they're adapting their style of communication and engagement to a child's age, their level of maturity, their concentration level at a specific point in time, and any additional or specific vulnerabilities that they have on top of being a child in an incredibly stressful, challenging situation. And the fourth and final section of the Good Practice Guide is awareness of key organisations that can support children in the youth court, such as the Youth Justice Team, and obviously working with them if it would benefit the child in the proceedings. And I think just to finish on the Good Practice Guide, other speakers have highlighted the vulnerability of children in the youth justice system and the youth courts as a key issue. And I think it's fair to say that the importance of engaging effectively with vulnerable children is the kind of golden thread that runs through all 4 sections of the Good Practice Guide.
Okay, thanks, Ben. And obviously what that guide does is very clearly set out from the regulator's perspective what we expect of solicitors practicing in the youth court. So that's with a view to helping people identify whether they've got any learning and development needs, but also to try and address some of the challenges we drew out at the beginning of this conversation. Helen, if I can come to you, please. Ben's articulated why and what the Good Practice Guide is, but from the Magistrates Association's perspective, what other advantages of the Good Practice Guide do you envisage?
So the Good Practice Guide is really helpful for magistrates in that it reflects the youth court bench book, which is something that I'm aware that if you're not within the judiciary, you might not be aware of, but it lays out a very similar good practice guide, very detailed guidance as to how to approach cases, as well as the different procedures that are required in youth courts. And I think that by having a good practice guide that's accessible and referable for solicitors and advocates in court, as well as one for the judiciary, it allows both parties to have that hook to talk to one another about what good practice looks like. And so from the magistrate's perspective, they'll know that this good practice guide exists and can possibly deal with any issues sort of there and then on the day and point people towards the good practice guide if they perceive any poor practice occurring. But that also is a two-way street, and both these documents reflect one another quite closely in that it's all trying to get this sort of common goal of the best experience for the child to reduce reoffending and avoiding that kind of punitive approach that does exist in the adult court system but shouldn't be present in the youth justice system. And by having this external standard, and the Magistrates Association has been involved in developing it, it just means that everybody knows where they stand in terms of the regulation. Everybody can pick up and work together on what a good youth justice system looks like.
Okay, thanks very much for that, Helen. And just perhaps a follow-up question to you. I mean, you talked about the similarities between the bench book and the guide that we've produced. Is there anything in particular from a magistrate's perspective they expect from solicitors and actually all lawyers in the youth court, and how do they help drive high standards?
So making sure that magistrates expect the same of solicitors as they expect of themselves and their magistrates colleagues. So it's, again, going back to what's been said before, understanding the different principles. There is no punitive element in the youth justice system. It is all about reducing reoffending, stopping reoffending, and having the best outcome for the child. But it's understanding the legal frameworks. For example, the Police Crime Sentencing and Courts Act last year slightly changed the remand tests that are involved, and being familiar with the need for considering the welfare of the child at each stage of the remand test and being familiar with those differences. And they do change quite regularly. Being up to date with that kind of thing really will help drive high standards sort of across the board. So it's making sure that everybody in court, magistrates, the legal advocates, CPS, defence, everybody is aware that this is the goal. And I think that there's issues across the youth justice system, for example, with high use of custodial remand, and making sure that you have that contextual knowledge and the knowledge that the remand test is different in youth court, that it has recently changed to try and reduce those high numbers of custodial remands, that wherever possible you're diverting away from the youth justice system generally, but also particularly diverting away from custodial options wherever possible, will help reduce that criminogenic factor that Kate was talking about before. The more you're involved in custody and the harsher sort of penalties that you're coming up against as a child, the higher risk you have of reoffending. And so it goes against the principles of the justice system to be pushing for that kind of thing. And so making sure that everybody's aware can really help improve the overall outcomes for all children who end up involved with the criminal justice system.
Okay, thanks very much for that. Let's move on now to perhaps look at some probably more practical steps that solicitors who practice in the youth court can take to address some of the challenges we've identified so far. But before we do that, Ben, I just wondered whether you could outline from the SRA's perspective what we as a regulator expect from solicitors who might practice in the youth court in relation to their learning and development.
Yeah, happy to, Richard. Thanks. And really excited to hear from Kate and Katya, the kind of specific things that solicitors in the youth courts can do by way of learning and development. I think from the SRA's perspective, it makes sense just to set out the kind of the obligation that all solicitors have to meet to maintain their competence to carry out their role by keeping their knowledge and skills up to date, and we call that their continuing competence obligation. And we have resources on continuing competence that set out the steps, the learning and development steps we expect solicitors to take to meet that obligation. And very quickly, those steps are reflecting on their practice and their strengths and weaknesses so that they identify their specific personal learning and development needs, and then planning and completing targeted training to address those specific needs they identify, and also recording the training they do and evaluating its effectiveness in addressing the underlying learning and development needs. And the good practice guide for youth court solicitors kind of sits under our continuing competence framework in a way as a targeted learning and development tool for youth court solicitors to use to help meet their continuing competence obligation and demonstrate good practice in the youth courts. And in terms of how we expect youth court solicitors to use the guide, it sets out what we expect, it sets out what good practice looks like. So solicitors should really, on an ongoing basis, reflect on what it says, think about their own strengths and weaknesses, what's going well in their youth court practice, what perhaps isn't going so well, or what they could strengthen, to identify the specific learning and development needs they need to focus on and address in relation to their youth court practice. And there are also some resources, supporting resources we published alongside the Good Practice Guide, which signpost to lots of useful other resources from other organisations, and also some really useful forms of learning and development, whether that's face-to-face training or kind of online written materials and things like that. And just quickly before I finish on this, going back to our review of the training records of youth court solicitors, although we found that most youth court solicitors were taking steps to maintain their competence, we found that only 39% had demonstrated that they were reflecting on their practice. And I think that's, given the unique challenges of practicing in the youth courts and how practicing in youth courts is so different to practicing in the adult criminal courts, as the other speakers have said. I think reflection is particularly important in this area, and it can sound like a really formal, time-consuming process, but it really doesn't have to be. Expect solicitors to reflect on an ongoing basis about things they're doing well, things they could do better, developments in their area of practice, just so that their learning and development can be targeted and effective, and so that they make sure that they're competent on an ongoing basis to do the best job they can for children in the youth courts and for the wider youth justice system.
Thanks, Ben, and that's a really clear articulation of what we expect as a regulator in terms of learning and development. I think the only point I'd perhaps add to what Ben has said is that actually, we expect solicitors to declare that they have done the things that Ben outlined to us on an annual basis, and that that's a really important declaration, and solicitors should make sure that they've done those things before making that declaration. And actually, we as a regulator do look at the number of people who have and haven't made that declaration as part of our ongoing intelligence work around the youth court. Kate, if I can come to you, we've talked a lot about kind of good communication. So I think it's fair to say that good communication is important in the youth court. Can you explain what good communication looks like?
Well, yes, but I might just start, if I may, with what poor communication looks like, because when you look at any research that's been done of the youth court, which has looked at children's experiences, there's a real common theme. And children describe the experience of going to the youth court as one where it's a process that's happening to them, where they feel that all of the lawyers are speaking Latin, that they don't understand, and they don't feel part of the process, and they don't recognise the child who's being described in court as them, and they don't feel listened to. And so I think that tells us what good communication looks like. Good communication is about spending time getting to know the child that you're going to represent, so that you can properly represent them in court, and so that they feel that they are the child who is being talked about, that you can enable them in an appropriate way to participate in the court process. We heard from Helen about how magistrates in the youth court, as compared to adult courts, want to speak directly to the child. And so you, as the lawyer, have to facilitate that process. We know that their child might have communication difficulties. So how can you ensure that they can communicate effectively, they can understand the questions being asked of them, and express themselves effectively in that court process, which is recognising, as that has what has already been said, that process of communication starts when that child sets foot in the court. It can be a really intimidating and stressful experience, and so your role as the lawyer is to try and look at ways to minimise that stress, so that a child is able to calmly engage with the process, and so that they can follow what's happening. They can understand what's happening to them, but also that they feel able to open up and share important background information with the lawyer who's representing them.
Okay, thanks, Kate. And Katia, if I can come to you. How important is understanding the background and needs of a child when practicing in the youth court? And again, Do you have any kind of suggestions on what good looks like?
Yeah, I mean, I think the importance of background is absolutely fundamental to how you represent a child. And obviously, you know, you need to understand when you have an adult client as well, but there's a different level of engagement that needs to be undertaken by solicitors when representing young clients with what's going on with them. And it can, not understanding what's going on in the background and what that child's needs are, leads to missed opportunities in terms of the case outcomes. So, for example, the solicitor who fails to recognise red flags around child criminal exploitation does that child a real disservice, and actually, you know, the case takes a completely different trajectory, which not only leads to a poorer outcome in terms of the criminal case, but that child's whole life potentially. And there are, you know, numerous other examples. So I would say that probably, you know, the majority of children going through the criminal justice system, you can justify having them assessed by an expert, not all, but large quantities. And you know, if solicitors aren't thinking in that way, there are missed opportunities, and often very early on. So you'll get children who have perhaps had interaction with the system for sort of minor offences, and it's only later that they're assessed, whereas if that assessment had happened earlier, it would have changed the whole course of their interaction with the system. So I think it's important that solicitors don't expect children to offer them information in the same way that adults might in their conversations with them. If they say, please could you tell me about your background, I don't think the child's likely to share all the information that they need. So I think they need to go into that work understanding that the onus is on them, the lawyer, to do the digging, and that digging involves building a real, genuine relationship with their client, and it involves looking, spending time digging through records, social services records, school records, medical records, speaking to other people in that child's life, members of the community, youth workers, you know, as well as in, you know, more formal sort of services. So it's a lot of work, and it's time consuming, and it's just the way it has to be.
Okay, thanks, Katia. We've had a question submitted from someone who's watching, and I think this one's maybe for you to pick up, Kate. It's can you suggest any tips or approaches that youth court solicitors can use to keep their legal knowledge up to date?
Yeah, thank you, Richard. I mean, it's a good question. I think in reality, just not just subscribing, but subscribing to providers of legal digest and information such as Crime Line or Westlaw is not enough. If you are practicing in the youth court, you need to go to organisations which have specialist knowledge and are focused on children specifically. So the Youth Justice Legal Centre has specialist resources. It's a hub where you can access recent legal developments as well as specialist legal guides that are addressing these issues that, when dealing with children in contact with the justice system, are very different as compared to adults, and so picking up on those specific issues is something the Youth Justice Legal Service Centre does well. They also provide webinars and training. There are other organisations that offer training opportunities, such as the Youth Practitioners Association, other organisations like Transform Justice or the Association of Youth Justice. You can subscribe to updates from the Youth Justice Board as well, to be aware of what is changing in the environment in terms of the justice system for children. And I think you have to have a professional curiosity and interest in understanding what are the prevalent issues in children's lives, not only nationally but in the local community. And this is something Helen touched upon earlier, that it's knowing what's available in the local community, is really important in terms of being able to represent that child effectively.
Okay, thanks. And perhaps a follow-up sort of question, Katia, to you. Kate talked about how legal knowledge can be kept up to date. Do you have any suggestions or tips on how solicitors can keep their practical skills up to date?
Yes, so I think, you know, to echo what Kate said about engaging with organisations beyond just the sort of classic legal update digest is really important. And continuously kind of looking for opportunities to find new strategies to genuinely communicate and engage with children. So trying to think outside of the box and trying to unlawyer yourself as much as possible whilst still remaining an effective lawyer. You know, some children respond well to using diagrams to explain things. So if you have to sit with a pen and pencil, a paper and pencil at the beginning of a hearing, or you know, when you meet your client, to explain this is the judge and this is what they're going to do, and you know, just adapt the way that you do your work to help engage children. And I think going to training and going to events which convene the expertise of non-legal authorities is incredibly valuable. Lawyers aren't going to learn how to do this from other lawyers. They're going to learn from speech and language therapists. They're going to learn from psychologists. They're going to learn from experts in how to practice cultural competence, how to be anti-racist. You know, there's a huge range of expertise out there, and it's all available. So I would recommend solicitors to do that. And you know, as Kate said, obviously at Youth Justice Legal Centre, that's something that we try to provide.
Okay. Thanks very much. Kate, if I can come to you, but perhaps just set a little bit of context before I ask the question. We do a lot of work in terms of understanding some of the challenges and the level of advocacy provided by solicitors in the youth court. And I think through our thematic work, we identified that perhaps some, but certainly not all solicitors practicing in the youth court who may have been doing it for a very long time, perhaps didn't spend so much time focusing on some of the activities that Ben outlined in terms of learning and development. You know, it's important for even experienced youth court solicitors to keep their knowledge up to date, isn't it?
Yes, actually, that's a really important point. I think what Katia has touched upon around just having that professional curiosity to want to continuously reflect on your practice and to improve the way that you communicate with children is really important. I mean, that is the fundamental step to ensure that you can effectively represent a child, is that you've earned their trust and that you have a good working relationship. And Katia mentioned unlawyering yourself. It is really important that you stop at the very beginning when you meet that child and introduce yourself and just have a chat about something nothing to do with the case, because they're a child and this is all big and scary. And all of those skills are about keeping your knowledge up to date. And it's also, you know, of course, the case, I think Helen touched on it, guidance and practice is changing all the time. So you need to make sure that you're keeping your knowledge up to date, but also the issues that children are facing are changing. So we know at the moment that county lines is a prevalent issue for children. It's about understanding what are the hallmarks of a child who might have been trafficked, so that when you meet a child from the first time and the Youth Justice Service tell you that they've been reported missing, they've been excluded from school, perhaps they're a looked after child who's been moved out of their local area and is no longer has support networks available to them, maybe they're a child with special educational needs. These are all factors that have been identified as factors that may make them more vulnerable to being criminally exploited. these are factors that are going to change over time. So that is not static knowledge. So it's really important that you keep attending training and you keep that knowledge up to date. And if we look back in time, if we look at child and adolescent brain development, when we the emergence of MRI scans enabled us to understand that actually children's brains are still developing beyond adolescence and into adulthood. But the important thing about what's happening to the brain during adolescence, and what explains why we often see that children offend and then stop offending, they offend for a short period of time and then stop offending, is because their brain is growing and developing, and the part of their brain that's growing and developing is the part that develops their rational thought and their consequential thinking. So they actually have a physiological lack of capacity to think through the consequences of their actions. That explains their behaviour. We need lawyers to understand that so that they can put that forward as important contextual information, either in representations to the CPS to perhaps take a different view of the criminal prosecution, or when mitigating on behalf of the child in court. And this is knowledge that changes over time. So yes, it's really important to keep that knowledge and expertise up to date, but it is worth acknowledging that there are some really fantastic solicitors out there who are specialists and have honed that specialist skill, and that you know, they're a really important part of the legal profession, and they should be celebrated. And if I may just also acknowledge the work that the SRA has done. You know, this good practice guide is really, really valuable, and it's really important that solicitors now have a resource that they can turn to, so they can be clear that every solicitor who's going to the youth court has acquired these skills and knowledge and attributes in order to be able to represent children effectively. So just want to applaud the work of the SRA.
Thanks very much for that, Kate, and thank you actually for all of your help in developing it. And I think what we're keen to do now is make sure that solicitors use that guide as a learning tool that Ben has suggested, but also maybe as a tool to help them sort of improve it if they think that's absolutely necessary. I'm just conscious of time, so before we pick up the last few questions I've got for the panelists, I just wanted to remind anyone watching, if they've got a question they want any of the panelists to answer, please submit that through using the link below, and hopefully we'll have some time to pick up your question. Helen, if I can come to you, Katia and Kate have provided some really helpful practical tips on how solicitors can keep and remain competent. Is there anything else you want to add in terms of tips for lawyers in the youth court?
Yeah, I think that the things that Katia and Kate have said have been so helpful. The Youth Justice Legal Centre is a tool that I use regularly, not as a practitioner. They really put out a lot of the helpful contextual information, and things like the Youth Justice Board as well. They're an offshoot of the MOJ but are independent, and they provide a lot of information about what's going on in different areas, about pilot programs. So, for example, we've touched on the national referral mechanism for potentially exploited children. There are lots of pilot areas ongoing right now that are undertaking a different approach to that, and you can find out about all the different approaches that are going on through something like the Youth Justice Board. You don't have to get down into the detail of all the policy decisions or the research or the evaluations of these pilots, but just knowing that they're going on and what issues they're trying to address in these different areas will, I think, be really helpful for youth court advocates to be able to understand those broader contextual issues and what the youth justice system is trying to achieve overall. It's obviously you're working on that one individual case, but from the policy side, there's always a broader arc of what the youth justice system is trying to achieve. So familiarity with those base principles and then understanding the contextual information will really be helpful for youth court advocates to understand why the procedures are different and therefore why they're important to employ in those individual cases that you're working on. I think the other couple of tips I would give is that there are things like youth court user groups, which allows everybody who goes to the youth court to engage, and magistrates attend police officers attend, youth justice services attend, and it's just an opportunity to have that kind of informal conversation where everybody feeds back to one another about what's going well and what's going badly. And that's where, we're hoping that this good practice guide will prove useful in those kind of situations where everybody can refer to the bench book, refer to the good practice guide, and identify what the good and poor practice is in their areas. And those user groups are also a really good way of finding out what's going on in your local area and what, for example, what community sentences are available, what the youth justice services in your area are going through, what their resourcing challenges are. Are they able to offer something like an intensive supervision and surveillance bail package, or are they not? And knowing that allows you to then make a better recommendation that might be in the best interests of your client and best interests of them as a child to, perhaps not be diverted into a custodial remand or a custodial sentence. And we know that having sort of the level of consistency across the youth justice system will impact how children perceive the process. And so I think use this good practice guide as a tool for the reflective practice. It will be really, really helpful in the long term for developing your skills as a youth court advocate. So those are my little tidbits of tips.
Okay, thanks, Helen. We've had a question submitted, and this is around organisations which youth court solicitors should be working with. Katia and Kate, can you give us some examples of the types of organisations that solicitors should be working with? Maybe Kate, could you go first?
Yes. Well, obviously, the most important organisation is the Youth Justice Service. So making sure that when you arrive at court, you speak to the Youth Justice Service or whoever is at court on their behalf. And it may be that solicitors can develop good relationships, so those conversations actually start before you arrive at court. But there are also other really fantastic organisations that are able to support a child outside the court process, which may be really important to what the outcome that you can achieve for the child. And I'm thinking of Just for Kids law that may be able to work with a child, perhaps if they're out of education, help them get back into education, and that may enable the court to take a different approach on sentence. It may also be relevant to whether it's in the public interest to prosecute a child. I'm also thinking about organisations like Abianda, which is based in London. It's an organisation that supports girls. Girls are actually, there are very few girls come into the formal criminal justice system, but they often have very complex needs, and having an organisation able to provide support to them, other organisations do this well for girls and boys like St Giles Trust. If those organisations are working with the child outside the court process, that can really lead to better outcomes for children. So engaging with services in your local area, church groups, community groups can be really important. Youth organisations are really important.
Okay. And any others, Katie, you think are really important that solicitors should have on their radar, either a local or national level, that they should be engaging with?
No, I think Kate's captured it all really. It's just, I think, being able to think on an individual level. It's not always the same organisations you need for one case as it is you need for another. So just being able to be a bit flexible in that way, and really taking the time to speak to that kid and that kid's family, or whoever it is that you come into contact with around the case, to see if there's, whether it's an organisation or an individual that might be in that kid's life for whatever reason, that can be fundamental, can really change how you build your approach to the case, and how you structure perhaps your bail application or sentencing, mitigation, etc. So yeah.
Okay, we're coming very close to being timed out, so I think it's a really good opportunity for me to thank you all, the panelists, for your kind of thoughtful and insightful views and tips. And I think, you know, certainly there's a lot a youth court solicitor could take away from this session, even if you're you've been working in this particular area for a very long time. So thank you all for your time. If you haven't had time to, if we haven't covered your questions that you may have submitted, we'll take those away, we'll look through them, and we'll see if there's anything we can do to answer them or cover in future webinars or in our communication. So we'll take any of the questions we've not got round to away. So on that note, we'd really want to hear what you thought of the webinar and today's session. Was it useful? Did it cover the types of content that you think it would? And also, what else would you like to have seen covered? There should be an evaluation link below this video stream where you can take 2 minutes of your time to let us know some of your thoughts. So and that will really help us kind of make sure that we are making sure that webinars in the future on this particular subject are really addressing the needs of youth court solicitors. So please take a couple of minutes to do that. So just finally for me to say thank you very much for you watching. Thank the speakers again, and have a great afternoon.